With some of these big things like Prop 50 and Duncan going to SCOTUS on the table, there are a couple things that happened that we kind of ended up skipping over, so it is time to turn back the clock as we have received an order in the Junior Sports versus Bonta lawsuit, bringing a finality to this lawsuit. We got some great news. Let's talk about it. Hey everybody, welcome back to the channel. Today we are taking a little step back in time, as with Prop 50 and some of the news on Duncan has become more and more prevalent. There was a case that we got an order for that we haven't talked about yet, so I thought it was a good idea to go back and talk about AB 2571 and our victory in Junior Shooting Sports Magazine versus Bonta. To walk us through that today, we have brought back Anna Barvir. She is with, she's an attorney with Michel Associates. She's been working on this case from the very beginning. I think we'll even find that in the court documents here. Anna, thank you very much for being on with us today.
Thank you for having me.
Absolutely. And guys, before we get into this, please, as always, be sure to like, share, and subscribe to the videos. It really helps the algorithms get this info out there as far and wide as possible. We have been knocking down gun laws in California, not just in the legislature before they become law, but also in litigation as they have already become law. We saw a huge one with Nguyen v. Bonta striking down the 1 in 30 law earlier this year. Of course, we saw new legislation on that in 2025, so we'll be fighting that one here. But this is also kind of a key victory, and it is one that seems like it's come to its conclusion. I think Anna is going to end up walking us through that today. So guys, please be sure to like, share, and subscribe. It really helps get this info out there so people can see how the ball is moving forward here in the state. But Jacob, if you could pull this up for me, we have the order here from the Central District Court of California on Junior Sports versus Bonta, and it reads like this. Plaintiff's motion to enforce mandate and issue preliminary injunction came on for hearing on June 10th, 2024. Anna Barvir and Donald Kilmer appeared for plaintiffs, and Gabrielle Booten appeared for Defendant Attorney General Bonta. On June 18th, 2024, this court issued an order granting in part and denying in part plaintiff's motion for a preliminary injunction. On July 7th, 2025, the Ninth Circuit issued a memorandum opinion reversing the court's order, denying in part the motion for preliminary injunction and remanding with instruction to issue a preliminary injunction against the enforcement of the entirety of the law. This court thereafter ordered the Ninth Circuit mandate filed and spread on the record. In accordance with the Ninth Circuit mandate, it is hereby ordered that during the pendency of this action, the named defendant, his officers, agents, servants, employees, attorneys, and other persons in active concert with them are hereby preliminarily enjoined and restrained from enforcing California Business Professions Code 22949.80 in its entirety. The Attorney General is further directed to issue an alert notifying district attorneys, court counsels, and city councils in California that enforcement of this law has been preliminarily enjoined in its entirety. It is so ordered. So, I mean, kind of a mouthful there, kind of walking us through the process. Anna, if you could, for those who haven't been following along for the last year or so on this lawsuit, can you go ahead and just remind us what Assembly Bill 2571 was, and really what I'm hoping to encapsulate here as we close out this piece of litigation is really how murky it kind of made the water in the Second Amendment community. Could you walk us through that?
Of course, I'm happy to. AB 2571, what we call the junior marketing ban, is a law that California passed on an urgency basis to ban all marketing and advertising by firearm industry members, which is statutorily defined and includes organizations like CRPA, but also magazines like Junior Sports Shooters Magazine, and of course, firearm manufacturers and sellers. And it prevents those industry members from marketing or advertising any firearm related products. So that includes firearms, ammunition, and any accessory that's used in conjunction with firearms, and doing so in a way that is designed or intended to, or reasonably appears to be attractive to minors. And the law set out a number of characteristics that make something reasonably attractive to minors, things like firearms in attractive colors or smaller sizes, advertising with by using images of minors, cartoons, or characters like Eddie the Eagle, for instance. So anything that would be considered reasonably attractive to minors, but it didn't limit it to if it would also might be attractive to adults. So what the law ended up doing, what the law ended up doing was preventing kind of giving no real basis on which to decide what kind of advertising is banned, other than the fact that it has to do with firearms related products and done by firearms industry members. And we immediately brought a lawsuit to challenge it on First Amendment grounds.
Yeah, and I remember kind of going through it as, you know, I am able to get out to some of these ranges, talk to a lot of people who work in programs throughout the state, and it was truly like a depressing time. The way that this law, guys, remember, like a lot of the conclusions that we have now at the time that this was first being implemented, we didn't necessarily have. We had ranges taking down SIG banners or Smith & Wesson banners because they didn't know that if a family of 6 with 4 kids came to the range, if they were going to incur $100,000 in fines for advertising to those kids. Programs, they came to a 100% dead halt. People just stopped doing youth programs, and that totally fits the culture side that Gavin Newsom said that he wanted to do. It's no surprise that he kind of spearheaded this campaign. If you guys remember, this was the bill that Gavin Newsom appeared on TV with the skull and crossbones behind him, talking about how it's just so awful and immoral that a firearms company would advertise firearms. Juniors do certainly shoot. It's been in a lot of the culture of America for a long time. But a lot of those programs that would be teaching the next generation of shooters had to come to a complete stop because you're incurring a $25,000 fine for every single incident. So the water was certainly murky there. I'm sure some of you who do work in those programs in California remember that. So it was like imperative to get an injunction on this law just as quickly as possible. Thank you, Anna, for walking us through that. Now let's talk about the pathing of the lawsuit and the introduction of the SCI lawsuit that kind of came along with it. How is it that these lawsuits ended up making their way through the courts? And I'm hoping, because there was some tomfoolery here, if you can be kind of specific towards the end when it seemed like there was a conclusion that had been come to with this law, and then the state comes back trying to play games with the Ninth Circuit. Can you walk us through the pathing of the lawsuit here?
Yes. So CRPA and a number of other nonprofits, as well as individuals, including individuals who are engaged in those youth sporting organizations that you were talking about earlier, because initially, you're right, the law actually did bar any sorts of advertising in those sorts of events. The law, after we filed our lawsuit, we pretty immediately filed a motion for preliminary injunction. And in response to that, and in response to the filing of our lawsuit, the legislature immediately got to work on AB 160. AB 160 was passed also on an emergency basis to clarify the law, to take out some of the, I think, kind of some of the very egregious points that we made clear through our litigation, which was what you were talking about, that it was affecting and halting these youth organizations events. So AB 160 clarified that those events were not part of this. And then we had to do a little more briefing as a result of the law changing. And then the district court denied our motion for preliminary injunction. Shortly after that, Safari Club International and some other organizations filed a very similar lawsuit. I think it was maybe it was a month or two later. And they too sought a motion for preliminary injunction, and they too were denied. And both of the cases went up to the Ninth Circuit. After full briefing and oral argument, we got a wonderful 3-judge panel opinion overturning both of the preliminary injunction denials and remanding back to the district court for further proceedings. Once the case came back down, the parties in both our lawsuit and Safari Club International's lawsuit were working with attorneys for the state And it looked as though we were going to get the full motion for preliminary, the full preliminary injunction we had moved for previously and been denied, because that's what the Ninth Circuit told them we were supposed to get. Some hijinks ensued, at least with our lawsuit. At first, for whatever reason, the SCI folks were first to come to terms with the state and got their order, their requested order for preliminary injunction filed. And the court in the Safari Club International case, which was not the same court we had, granted their full motion for preliminary injunction, enjoining the enforcement of the entire law. Like the day later, opposing counsel came to us and opposed giving a full motion for preliminary injunction, told us that we could only get a preliminary injunction on subsection A, which is the portion of the law that's very clear that they're banning this type of advertising that's attractive to minors, and not they would oppose if we sought an injunction of the enforcement of subsection B. Subsection B was a kind of an interesting law. They marketed it as a law that prevents these firearm industry members from keeping the any minors contact information. So they were marketing it as a privacy. But the only time that firearm industry members couldn't keep this information was if they wanted to use that information to advertise or market to minors. So it effectively does the same thing as subsection A. And so we had to litigate this with the district court, and the district court, as you mentioned, when you read the order, initially granted it only in part, gave us an injunction on the enforcement of subsection A, but not subsection B. After that happened, the judge in Safari Club International was like, oh no, I messed up, and did the same thing, and pulled back the initial order enjoining the entire law and made it so that it was also only subsection A. Our case was immediately appealed to the Ninth Circuit. The Safari Club International case stayed in the district court where they moved for judgment on the pleadings. As we went through to the Ninth Circuit, we moved to ask the same panel that heard our case before to hear this one again as what is called a comeback case. And of course, they granted that. It was a very favorable panel. They wanted to tell the district court that we already said what we meant. And so they took the case, and again, we got a memorandum decision that said we meant what we said. The entire law is unenforceable because it is a violation of the First Amendment right to commercial speech. At some point, either while we were in appeal or right after our decision, the Safari Club International judge, I think, denied their motion for judgment on the pleadings, but I think it was it might have been a kind of a procedural thing. And since then, we have been back in front of our district court judge, and that's where you got the full preliminary injunction order that you read before.
And guys, yeah, we did do a video on it. If you were able to watch the comeback to the Ninth Circuit, it was a little bit comical. I mean, it makes sense. They want your kids, right? They don't want the next generation to grow up with firearms as part of their culture. So sure, they're going to make up or do anything that they need to do to win a case like this. But it went back to the Ninth Circuit, and the judge just kind of throws his hands up and says, "Why are you in front of me?" And then when they try to make their claim, they're like, "But you never brought this up in the first place. You don't litigate like that." So he threw him out pretty quick. That was kind of entertaining to watch. So Anna, I mean, we talk about this stuff all the time, and I think it's good to look at it like, I mean, each individual lawsuit kind of like a war. You can have battles, you can have victories and losses in those battles. Is this, though, the conclusion of the war for Assembly Bill 2571 and this ban on youth advertising? Is this kind of the last thing that we're going to see this order?
In this litigation, we do look like we're wrapping it up. After getting the preliminary injunction and the mandate spread, the district court advised the parties that she saw no reason that this couldn't, this case couldn't settle after what the Ninth Circuit has twice said. So the parties are currently working on that. We have filed a notice with the court giving them an update on how that's going. We're very close, but we're not quite there yet. But I would suspect you'll see very soon that this case will be wrapped up, neat and tidy, and we'll have a permanent injunction on the entire law.
So looking forward to that permanent injunction as we're working that way. I guess, I always like to think of what is, something that we can look forward to. I am sort of curious, how this plays out. We did kind of as a community celebrate a law getting stricken from the record with the Nguyen v. Bonta lawsuit. That doesn't really happen a whole lot. This is talking about the law being enjoined. Can you explain this to us a little bit? Does this law just stay on the books and is ordered by this court to not be enforced? How does that work?
That's a good question. So generally, when a law is determined to be declared unconstitutional, it will be enjoined from enforcement. And generally, those laws will stay on the books. They just sit there as dead laws. A lot of people, I think, saw this kind of most in their face was perhaps like when Proposition 8 passed. And then it was declared unconstitutional, and it stayed in the Constitution for many years until the voters decided to formally repeal it a couple years ago. That's what happened in Nguyen. It was declared unconstitutional to limit to one gun, so they repealed that law and replaced it with another. That happened with the non-resident carry in CCW. So it does happen, but it's pretty rare. And so what you're going to see in this case, unless and until the legislature acts or the people act, we simply we'll have a permanent order that says the law is declared unconstitutional and the state defendants are enjoined from enforcing it. And as you heard me say, I did say the state defendants. And in this case, there is an unfortunate bit because the law expressly authorizes also local law enforcement, so county councils and district attorneys, as well as private individuals to enforce the law. So that's why we are seeking and got a notice from the DOJ that says this law has been declared unconstitutional so that local law enforcement are actually aware of the outcome of this case, and they know that if they were to enforce it, a lawsuit's coming their way. So absolutely. As long as it sits on the books, that is potential.
Right. So a victory nonetheless. So the law is not going to be enforced as a violation of constitutional rights. And it kind of sounds like, there is a process to look forward to, and maybe we can discuss that about going after something like that, but it's got to go back to the legislature if you're actually going to strike the law from the record. But overall, a victory, guys, is what we got here. That this is looking toward its finality. It is enjoined. It is not going to be enforced. I guess, Anna, as we look past the settlement, I guess I'm curious on your thoughts on Second Amendment litigation. What do we have to look forward to within the state right now? What should we be paying attention to?
What cases? What laws? I'm sorry, Ben. I'm constantly working on Second Amendment, First Amendment litigation that deals with firearms rights. We're still fighting BNL Productions, which is the statewide gun show ban. So hopefully we'll start to see some movement there. We are continuing our CCW Reckoning project. We are working to challenge what Santa Clara County's extremely high CCW licensure fees, as well as their psychological testing requirements. CRPA versus LASD continues going. Some of that will be settling soon. So you should look forward to really good news, I think, hopefully soon. And of course, Duncan is sitting in the Supreme Court. So hopefully we will hear from that sooner than later. Hopefully,
yeah,
and they'll take it.
Yeah, and hopefully we can get some good progress with Duncan too. And actually, that's a great reminder. I think Jacob will have to remind me. I think we're scheduled to talk with Matt Cabero on some of the new regulations that have come out from DOJ on gun shows as well. So maybe another talking point there, another thing to look forward to. And I know that you're busy. I appreciate you very much, and thanks for coming on and sharing with us today.
Of course, I'm always happy to be here.
Well, thank you very much. And absolutely, guys, please, one more time, be sure to like, share, and subscribe to these videos. If you like this content, if you want to get it out there, we are winning some of these battles. This was a great example here with AB 2571. So if you can, it's a great way to directly contribute to efforts just like this one that we're talking about today. Thanks again, guys. We'll see you on the next one.